Now we are going to start our webinar on overview of intellectual property by Dr. D.M. Karunarathna. He was a former Director General of National Intellectual Property of Office of Sri Lanka. First of all, I would like to invite Professor Trishan Perera, who is the Director of USJ Tech Trans Office. So I would like to invite him to give a brief introduction about the USJ Tech Trans Office and what we are doing. Professor Trishan. Okay.
Right. A very good evening for all of you. I think we have some participants still joining. So first, so on behalf of the USJ Tech Transfer Office and the University of Sri Lanka, I would like to welcome you all to this webinar on intellectual property commercialization. So thanks for joining. So the main objective of this short webinar is to give our university academics and researchers about a brief introduction to intellectual properties and how we have gone about commercializing these technologies through the UBL cell. As you may already know, the UBL cell or the University Tech Transfer Office was initiated in 2019. The funding of the Ministry of Higher Education. So the main objective of setting up these tech transfer offices or the UBL cells in state universities was to promote the commercialization of research findings. As we all know, now in the recent past, in our university, we have made tremendous progress on the research side because we have put a lot of money into research, and we have introduced various incentive schemes for researchers to appreciate and recognize their works. So through that, we have been able to promote the research culture. But we are still lagging behind in terms of this intellectual property or the research commercialization side. So through the UBL cell and the Invention and Venture Creation Council, we are currently working on promoting this commercialization of research findings, because we know that every year we put a lot of money into research and people do a lot of research, but and some researchers come up with very interesting research findings, but unfortunately they hardly come out of shelves or they go out of the university boundaries to the market. So the University Tech Transfer Office, our main objective is to identify these kind of commercializable technologies or the technologies with commercial potential and facilitate the commercialization process. So up to now, I think we have commercialized almost three technologies or products. To the medical faculty, we have commercialized a medicine or a traditional medicine in a new way, Sudarshana suspension. And then from the technology faculty, we have recently commercialized a technology which could be used to produce biodiesel. And there are several other technologies which are on the verge of commercialization. So from our side, we have been working very hard to find these technologies and commercializing them. So we want, as researchers, and from the University Tech Transfer Office side, we want our researchers to be more aware about what are the intellectual properties and what sort of methods or what are the procedures we have to follow in commercialization. So to give a little bit of heads up or an introduction to this rather new area for our researchers. So we have organized this webinar series to make you more aware about the intellectual properties and how to commercialize. So that's the main objective of organizing this webinar series. So I hope we have a very um, uh, an expert in this field who will be joining with us to enlighten you about the technology commercialization, Dr. Karunarathna. So I hope you will in the next few minutes, you will hear a lot of interesting and very informative presentation from him. And at the end of the presentation, of course, we can have a discussion. So with that, I hand over the forum to Mr. Trishan Perera, who is the moderator and our manager at the USG Tech Transfer Office. So over to you, Trishan.
Thank you, sir. Now I would like to invite Dr. D.M. Karunarathna, who is the Director heading at the Intellectual Property Division of Nithya Partners and former Director General of National Intellectual Property Office of Sri Lanka. He has written several books on intellectual property. I'm also, I would like to say that I am privileged to moderate this session because he's my intellectual property lecturer at Sri Lanka Law College. Dr. D.M. Karunarathna, sir, it's over to you.
Thank you, Trishan. Thanks for inviting. Today I propose to share some thoughts with all you, particularly intellectual property, what it is. So I guess there may be academics who and researchers who are aware of intellectual property, and still before we enter commercialization and other parts of intellectual property, and we will have a brief introduction to intellectual property, and I'm happy that I can join the University of Jayewardenepura because this is my first time actually I'm having any connectivity with Jayewardenepura University. I can remember a few years ago, Dr. Herath, who passed away untimely, we were in the academic board in a particular institute, and he invited me to do some lectures in your university, but I could not make it because I was very busy those days, and I had a problem with traveling up and down. So sorry. It's my pleasure to actually help you. So intellectual property. This is not something new. It means, so I am by profession, I am a lawyer, and I have been an academic throughout also, because my first was teaching in the Colombo Law Faculty, and I have taught law in some of the foreign universities as well. And at the same time, I have been an administrator as well. So I know a little bit about this subject, how it works, what it contains, what we should do it, and all sort of things. Little bit. Let's see how we can share some thoughts. So intellectual property in lawyers' terms, it's a set of legally enforceable rights resulting from intellectual activity in industrial, scientific, literary, or artistic fields. Okay. And actually, this is the definition or explanation given by the convention establishing the World Intellectual Property Organization. And intellectual property is a form of property. Actually, it was not considered property some time ago, but now it has become a form of property with some unique features of its own. So property means, ladies and gentlemen, you can own it like any other properties. So your house, your car, your pen, you can own it, you can use it, you can alienate it. If you like, you can destroy it. Okay. So it has several characteristics of associated with property. Okay. So for example, intellectual property is an asset. I underline it's an asset and has a monetary value and can, like any other form of property, be owned, transferred, sold, and licensed. This is a kind of intangible property. It's tangible property as it may be identified, as it may not be identified or defined by its own physical parameters. Okay. So when you create a poem, when you create found an invention, of course, there is no physical parameters for the invention, but you have to put it in a discernible, identified form. Then only it becomes something identifiable, something perhaps protectable. Okay. So just keep it in mind, ladies and gentlemen, it's a form of property belonging to you. Next. So looking at intellectual property, I have been telling this for many people in Sri Lanka at seminars, workshop, training programs, our television, radio, starting from early 90s or mid 90s. I came to the intellectual property office from the intelligence department, fortunately or unfortunately. And from that onward, we want to progress this subject. It was unknown by early 90s. So we did a lot of work to promote this. And of course, we help Moderator University, etc., etc. So in all these places, ladies and gentlemen, I have been telling this Kumaratunga Munidas, what he said, actually, nation does not create, nation does not progress. You know it, and that is why we are like this. And I can remember, I want to tell you a small story. Actually, I picked it up once in Japan, okay? And in 1900, okay, 1900, the first president of the Japanese Patent Office, he was visiting the US Patent Office. Okay, his name was Koriki Takashi. Okay, Takashi. And this is what he said, ladies and gentlemen. We have looked about USA to see what we have looked about us to see what nations are the greatest, so that we can be like them. We said, what is it that makes US, United States, such a great nation? And we found that it was patents. And so we will have patents. So this is the first Japanese head of the Japanese Patent Office said. He was talking about the importance of patent. And you know where now USA is. Okay. So contents, as far as contents of IP is concerned, intellectual property includes rights relating to areas such as literary artist scientific work, that is writing, whatever it is, music, okay, and it comes under copyright law. Then performance of performing artists like singers, phonograms, that is sound recording, and broadcast, invention. That's the critical area for you. And industrial design also applicable to people like you, because you are thinking of commercialization. And of course, trademarks, service mark, commercial names and designations, protection against unfair competition. That's also important for you in doing business. And geographic indications like Ceylon tea, new plant varieties, and undisclosed information, and layout designs of integrated circuits. That is, of course, in Sri Lanka, we don't have so far any registration in this layout designs of integrated circuits. Okay, next one. So if I just touch upon international dimension, I mentioned this for a reason that, remember, ladies and gentlemen, always intellectual property rights, like any other rights, are territorial. Okay, that means when you have protection for your intellectual property rights in Sri Lanka, it's protected only within the jurisdiction of Sri Lanka. And once you get the patent in Sri Lanka, it's protected in Sri Lanka. And if you want to protect in other countries, you have to get the patent for the same invention in those countries. Okay, so there is nothing called international protection of IP rights or international patents. Please keep it in mind. And always you get the patent national or regional, like EU. Okay, but international convention, though IP rights are territorial, international conventions have made arrangement for obtaining protection for your intellectual property rights in different countries. And actually, say, for example, various international organizations like the World Intellectual Property Organization, to which Sri Lanka is a member, already WIPO is administering 26 conventions on IP. And this is any international law. This is one of the highest number of international conventions. Okay, it includes Paris Convention for the protection of industrial property like patents, designs, etc. And Berne Convention for the protection of literary and artistic works like writing, etc. Rome Convention for the protection of sound recording, performers like singers' rights, broadcaster rights, and WIPO Internet Treaties of 1996. They try to address, particularly in the copyright and related rights areas, the effect of internet, communicating your work through internet. And Patent Cooperation Treaty, which enables, Sri Lanka is a party to Patent Cooperation Treaty. It enables you to make one application to the WIPO, designating various countries where you need the patent protection, which application is treated as one application among all the designated countries, and one application, then WIPO do the basic works. Thereafter, patent will be granted or rejected by the designated countries within their jurisdiction. Okay, so that is WIPO treaties, some of them. And TRIPS agreement, the agreement on trade-related aspects of intellectual property rights, coming under the WTO. That is the most comprehensive intellectual property treaty or instrument, international instrument, ever the international community has made. And any country who wants to be part of the WTO, the World Trade Organization, you are talking about commercialization, that country has to be part of the TRIPS agreement. Yeah, we are a party. We are party to everybody, everything, but I don't know how we are using it. Okay, and Universal Copyright Convention, that is not very active on copyright under UNESCO. And then UPO convention that relates to new varieties of plants. New varieties of plant means the breeders' rights, like all our rice now in they are breeded rice varieties. Batalagoda BG, or MI vegetables, MI, Mahilup Pallam, as you know, gentlemen. And that is why these people are now saying that it is various about these various things, about the current thing, right? And these various international organizations involved, and Sri Lanka is a member, Paris, Bern, PCT, TRIPS major convention. Okay, so the message I want to share with you is your intellectual property rights can be protected through all these member countries all over the globe, and you are required to protect, or Sri Lanka is expected to protect the IP rights of the nationals of all these member countries under national laws. And remember, national laws are harmonized due to the international convention. Now, intellectual property law is in every country convention based. Therefore, substantially, these laws are harmonized. If you know the patent law in Sri Lanka, it's very easy for you to follow American law, Indian law, European Union law, whatever it is, laws. So, with that message, we move to the other slide. And remember, when you talk about commercialization of IP rights, first you must acquire IP rights. Okay, and of course you create, there are two methods of acquiring intellectual property for commercialization. That's you acquire through buying technology or trademark or whatever it is. Okay, it already exists, particular technology exists, that you know you are in the technology transfer unit division, so you know it. And second is you create intellectual property like your universities do it now, and then of course you have to acquire those rights. There are two mechanisms. One is registration. You have to register, say, your trademark. It's a requirement for commercialization as an individual organization. You have to register it. An industrial design which gives a new appearance to a product in industry. And your invention, you have to get a patent. Okay, this procedure you have to follow and acquire the rights. And there are certain rights, of course, like copyright, your write-up, your computer programs. You can acquire rights without any formality, without registration under the international regime. Any country. But remember, invention, the technology, your invention, whatever it is, the computer programs, if it is an invention, it can be protected under patent law. And if it is just a write-up, it can be protected under the copyright law. Okay. And as here I mentioned in the last paragraph, IP rights are territorial, as I mentioned. Okay, next one. Then rights. Every item, category of IP attracts defined and specific rights. They are well defined and specified. For example, marks, patents, etc. They have the right, the registered owner or the patentee, say in a case of patent, the right to use the particular intellectual property. If it is a trademark, you have the right to use it. If it is a patent, you have the right to use the patented technology exclusively, while excluding others from using that, precluding others from using it. And assign it. You can assign the technology. Say in your university, you develop as a researcher a technology. You can of course obtain a patent and assign the patent to another company. Or even you can, without even getting the patent, you can assign the invention so that that particular company or organization can obtain the patent in its own name. Okay, it can be assigned and license the technology. Once you obtain the patent, you can license it with keeping the ownership. You permit others to use under your supervision. Under license fee, you permit others to use. That is how actually mostly technology transfer occurs. And say, for example, once you acquire rights for any intellectual property like this, your rights are limited by time. Say a trademark, 10 years valid, but you can renew it for consecutive periods for forever, each 10-year period by paying a renewal pay. Okay. And patents, once it is granted, it's valid for 20 years from the date of application for the patent in Sri Lanka. And remember, after the grant, you have to renew the patent starting from the second year from the grant every year with the payment of a renewal fee if you want to keep the patent alive. So please keep it in mind, ladies and gentlemen, once you get the patent, you have to renew it every year. You can pay the renewal fee all 20 years, but it doesn't happen because you renew it depending on the commercialization and how you create wealth, how you earn money. If it is useless, you don't renew it. So that you have to keep in mind. And of course, there are certain areas which don't have time limit, like geographic indication, so undisclosed information. And remember, any invention, I will come back to you it before I forget here. Even without patenting it, you can protect it under the undisclosed information or trade secret. Provided you can, it's secret, you can keep it secret so that others cannot identify it through reverse engineering or whatever it is. And then it has financial value. If these three requirements are met, your invention, it can be protected. It is protected under undisclosed information law. Actually, now in the USA, earlier it was, say, for example, it was federal law, state law. Now it is federal law. And consequently, in the USA now, a few years ago, it happened. Actually, they were talking about, rather than patenting, they want to keep it in as much as possible as secret. Because patenting is costly, ladies and gentlemen. Okay. So here I have mentioned exclusive in the sense that all rights, exclusively you are entitled to use it, or whatever it is, exercise those rights. And exclusive, you can exclude others from performing those acts. And there may be some limitation also. Say you want to get the patent, that limitation, there are some limitations like time limitation, as well as, so for research and education purposes, the protected technology we can use in learning, teaching institutions. Okay, continue. Enforcement of IP rights. Once you acquire your IP rights, those rights can be protected, enforced through the judicial intervention. Okay. So if your rights are violated, you can sue the infringer in the civil court, commercial high court based in Colombo, and you can ask for prohibitions, orders, injunction, and ask for compensation for the loss you suffered. And in addition, or alternatively, you can make a complaint to the police, and police can investigate like any other crime and prosecute the offender, and the punishment is fine or imprisonment or both. Fine is 5,000 rupees and imprisonment is 6 months imprisonment. And if it is a second or subsequent conviction, is double. The magistrate court has the jurisdiction. And in addition, customs authorities also are empowered to control some sort of infringement of intellectual property rights, in the sense that the customs, they are entitled under the law to prevent export and import of any products, any goods in violation of your intellectual property rights. You can make a complaint to the customs if there is any doubt, or on their own, even the custom officers, they do it. Okay, so there are 3 mechanisms for the time being. For people like you, it's civil remedies, civil litigation, criminal sanctions, and customs control. Okay, next one. Then, of course, we just go to few areas in little bit detail. Okay, so invention, probably you are aware what it is. So patents are granted for invention. And ladies and gentlemen, invention is a practical solution, a product or source process. It can relate to a product or process, practical solution to a problem in technology. Okay, so it's technology. It's not science. It's technology, and you encounter a problem in technology, and you find there is no solution to that problem in the existing prior art. Prior art means the existing body of knowledge relating to the particular area or particular category of the subject that your invention relates. There is no solution. And then, of course, you find a solution. And that solution works practically. That is the invention. It's a practical solution. It can be the product or a process. And it addresses the problem in the existing technology, which doesn't have an answer at the moment. And you find the solution. While you are finding the solution, you contribute to the advancement of the particular technology. Okay? And patent granted to an invention which is new, which is industrially applicable and involves an inventive step. Okay? I think I should explain at this moment these 3 areas little bit for your information, ladies and gentlemen, rather than going further. Invention new in the sense your invented technology is not disclosed anywhere in the world prior to you make the application to the patent in the National Patent Office. It's starting from the point you lodge the application, the examination technically is supposed to carry out from that point backward time immemorial. So technology, there is no Sri Lankan technology, there is no Indian, no American, no whatever it is. That's technology, you know. And once it is granted or once it is disclosed, it's known. And once it is known, it is not new. And even it may not be known in Sri Lanka, but it may be known to some corner of the world, then of course it's not known. So examiners, probably you must have, at least some of you all must have visited US or Japanese or UK or some patent office, at least Indian. So you must have seen that how many examiners they have. Mostly PhD holders in the particular field of technology. And in one technology, say chemistry, they must have in different areas, different experts. So they know basic. Actually, the examiners are not expected to know technology what it is, but they must know basics of technology, and they must know basically to understand your invention and the existing technology. If your invention is disclosed, then of course it's not new. So novelty means that technology is not disclosed until you make the application to the patent office. That means there may exist the same technology which is not disclosed to the public. Say, I have invented it, I have privately using it without sharing it with anybody. Then of course, you can be the second inventor, and you make the application. You make the application to the patent office, and then of course, because I had not disclosed it, your invention is treated as novel. Okay, and probably you are aware, ladies and gentlemen, that in the USA, until recent past, they were talking about that not this first to apply concept, but first to invent. Actually, when we made the law in 2003, this became a matter negotiated, but finally we continue to do the first to apply, but later on, during President Obama's time, they introduced the first to apply system rather than first to invent. And reason may be, probably you are aware most probably that telephone, as we know, I think if my recollection is correct, we know as the inventor is Graham Bell. In the school, we actually learn as Graham Bell. Am I correct? Probably, no? So, actually, Graham Bell was not the first inventor. The first inventor was one Italian-American, Antonio Musi. And Graham Bell patented his invention after 16 years of the invention of Antonio. And actually, US Congress recognized this fact in 2002. Okay. And then, of course, airplane also, there was the talk about that. Not Wright brothers, but German American. I think he invented it 1901. His name was, if I don't know how to pronounce it, Gustov, G-U-S-T-O-V, Whitehead. Okay. And of course, this was revealed in 2013. And they also talk about that they were going to do something like in the Graham Bell's invention. I don't know thereafter what happened. I didn't get information. I was not interested. So anyway, ladies and gentlemen, just I want to tell you, this is what happened. It's a question of disclosure. Okay. And then, of course, second is industrially applicable. That invention must be something that can be made as a product in industry, or something can be used to make a product. That means a process. Okay. So your solution can be product or a process. It must be. It can be something useful to society as a product, as a process to make a product. That's a must. So, and involve, and its third is it must involve an inventive step. And this is somewhat controversial. Many jurisdictions, there are thousands of judgments all over the world addressing this issue. Many issues, even 2 years or sometime like that, even the UK Supreme Court came out with new approach, with somewhat in line with the EU approach. So the inventor step means, in simple, very, very simple terms, ladies and gentlemen, the particular invention is not obvious to a person who is a general skill in the particular field of technology. Okay, so you test the invention in the context of a generally skilled person in the particular field, and he may not be an expert as of the level of the inventor. Okay, but he's generally he's aware basics very well, right? See, maybe the inventor may be a PhD guy, but that person may be just a bachelor's degree in particular area, but with work experience. Or even without all these things, but a workman, foreman in the particular area, that guy can be. So it depends on who the general skill person is, but he knows the workshop environment. He knows workshop environment. What it happened? What's this funny thing? Okay, and then of course, when the court or the examiner steps into his shoes, that new general skill person shoes, and look at the invention, then of course that invention is obvious. That means it appears to a general skill person there is nothing much. Then of course, and remember that must be a genuine person, and then of course it's held to be, if it is not obvious, held to be involve an inventive step. That means the law tries, ladies and gentlemen, to prevent patenting existing technology in different forms. That is important for researchers very well. And second is, it doesn't permit a type of inventions. Of course, there are some intellectual contribution, but still it is just a workshop improvement, but not really contributing to the advancement of technology. So if the general skill person finds that it's just any workman in the workshop can do it, little bit thinking, then of course it is not, it is obvious. And if not, it's not obvious. Okay, so consequently, it's a matter of facts, objectively tested, whether your invention contributes to the advancement of the technology in at least simple way. Okay, so once these three inventions requirements are fulfilled, your invention is something patentable. Okay, So, ladies and gentlemen, whatever you do, please look at these aspects prior to you think of patenting whatever it is, these things, because you are the best person to do it. Okay, the people who does the patent drafting, we encounter various issues. I'll come back to you later, but you must know what you have done, what are the limitations of your invention, all sort of things you must know as a researcher, as a technologist. Okay, so that's important. And then, of course, undisclosed information, as I told you, if it is secret, if you keep it secret and with some financial value, it's protected. If there's no registration system, you just say, for example, now you know very well that most valuable trade secret of the world is, they say, Coca-Cola recipe. And there are instances, of course, even Sri Lanka, we have come across one or two companies. We have worked with them to protect their certain formula in respect of certain various things. Okay, the employees leave and try to disclose others. Therefore, always remember, ladies and gentlemen, when anybody in your organization leaves, if you recruits anybody, there must be a clause in the letter of appointment to ensure that that person will not disclose, acquire, or use the information. And if it is not sufficient, you feel, have a separate non-disclosure agreement, at least as a safeguard. So that's important. Then trademark is a visible sign for your business. You have to, if always you have to have a trademark. You look at it, all these trademark, Maliban, Siddhalepa, say Apple, all sort of things, they are running under the mark. And people buy, branding guys will tell you, the people buy not the products, but the brands. Okay, so brand is the trademarks, use of trademark, how you use the trademark for commercialization. So this is a trademark. It's a visible sign distinguishing your goods or services from the goods or services of your competitors. Okay, so it's essential, ladies and gentlemen, for commercialization of your product. If you want to do your business on your own as an individual or as an organization. So have a trademark if you want to have your own business in your institute. You can do it. And industrial design. And industrial design is a design which gives a new appearance to a product in industry or even handicraft. Say you find an invention, there is a product, and of course you can, even for your product, you can give a new appearance through your new design. And even forget that, even you can probably, I was telling actually throughout our industries, think of actually design. When we were young, we didn't have these Japanese cars and other things. We had only Japanese Bonica. So they started it. So you can probably start designing various designs for industry. Industry, say, tie design, sari designs, pen designs, toothbrush designs, whatever it is, right? So it is a design which gives a new appearance to a product. You register it, get the protection. It's valid for 5 years, but you can renew it for 2 consecutive periods, and it's something attractive to the eyes of the consumers, and consumers buy. That is why, say, our shoe industry, they annually they put to the market quite few designs, shoe designs, and ladies buy. So this happened. So another area, ladies and gentlemen, probably in your division can think of. And literary and artistic work, that's your writing, your research papers, your articles, even your music, your painting, etc., protected. And under copyright law, remember, only protected expressions of ideas, not idea. Say your technology, in your invention, you put it in writing. That writing, what that contents are not protected under the copyright law. The manner in which you express it only protected. That the contents, the substance is protected by the patent law. Okay? In your research paper, you have to keep it. There are 2 areas covering your research paper. And related rights, the performances, so all sort of things, those things, they are not very important for you. Anyway, related rights covers performances, the acting, all sort of things, and sound recording, like producers sound recording. In your art faculty, if you make a sound recording, DVD, and broadcast, of course, radio, television programs. Next one. Okay, so the current Intellectual Property Act is the Intellectual Property Act 36 of 2003, just for information. It covers both substantive area and procedure and enforcement, all the areas as I mentioned. It covers inventions, marks, and all sort of areas except new plant varieties. We don't have a new plant varieties. Okay, if I involved in any agricultural area, if any plant to develop, even hybrid, we don't have a law. Though we are required to make a law for the protection of breeders' right. There was a big demand. They were making a big, they were making a request, the breeders at Batalagoda, Mahayuluppallama, and there is another one in Gaul. And actually we did the law just before I leave the IP office. We Agriculture Department, Ministry, and our ministry, we did one. And we put up a joint cabinet paper, and cabinet approved it, went to the legal draftman. After I left, I don't know what happened. And of course, all this, what I mentioned earlier, substantive provision, rights, acquisition, enforcement, management, all sort of things are included in the current Intellectual Property Act. It almost, except plant variety law, it complies with the TRIPS agreement of the World Trade Organization. Okay, so let's go to the next one. So, ladies and gentlemen, with all these things, I want to tell you, this intellectual property is an IP, is an asset. I am sorry, this first one I have put it, IP rights and assist. It's not IP and asset. I am sorry. I'm a very poor typist. IP right are an asset. Okay, sorry. Please correct it. IP assets are the intellectual property assets are the collection of IP rights. They have, in combination with human capital, economic value. Okay, So IP right, just line your patent doesn't create any economic value. It has only potential economic value. It is not, we don't call it real IP asset. It's a pathway to IP asset. And you have to put it into practice. You have to make it. Then only you need human capital, know-how, and commercialization expertise, and many other resources. Then, of course, when you combine your technology, asset, whatever it is, with human capital, it generates economic value. It goes to the level of economic value. And therefore, it brings wealth even to a nation, even to an organization, and to an individual. Consequently, the IP asset management is a crucial area for you people. Actually, some time ago, I can remember we were working with the University of Moderator. I can remember Professor Anand Javardhana was the dean, of course. Then, of course, we were helping them to, or we were cooperating with them, and they did a lot of work for the actually, not we actually, and for the development of IP policy for Moderator University. Okay, and even I went to Rajarata University. I delivered few lectures because I had a professor who was my classmate in the school. He wanted me to go there and make some class. I did, and I don't know thereafter what happened. And probably a few weeks ago, I did a lecture to Kelani University also. They also, I think, going to have one. Probably, I request you to bring your attention to having IP strategy, IP policy for the management of your IP rights. Even before you do it, commercialize it, you must have some sort of policy. IP as management is crucial for enterprise. I put it here, enterprise. Enterprise includes even individuals, ladies and gentlemen. Any person who wants to commercialize. In having competitive advantage and wealth creation. And IP asset management embraces, it's another subject, ladies and gentlemen, independent subject. Embraces various elements, IP policies, and of course required infrastructure and creation or acquisition and creation and acquisition and use of IP, monitoring, enforcement, etc. And of course, awareness building, not only among your own staff like this, and of course, even those concerned among the consumers, among the competitors, etc. And human resource development within the organization, required human resource development. So these are some areas which covers which cover so-called IP asset management. Just think of, ladies and gentlemen, what we can do within your organization in this aspect. It's like any other, because you have your university has a lot of property. You talk to accountants and they have every chair in their books. Even every cent in their books. But I don't know whether they have anything in their books about the inventions you create. They must have. They must have. I have been telling this throughout, even to the private sector, ladies and gentlemen, as the Director General and later on even as a practicing lawyer. Right? So, you must have that arrangement. Necessarily, you must manage it properly. What are the university? Whether you have anything, you just check with your accountants. Whether you are in your own organization, whether you have asked your own people to have it recorded. This is what we have. This is why I estimate the value of our intellectual property before we commercialize, because if you want to negotiate it with somebody to transfer technology, you must know the value. Without valuing your intellectual property, your patent, your technology, you don't know how to negotiate with. So these are very, very crucial areas, ladies and gentlemen. Okay, so Trishan, please move to the other one. Then, of course, with that, imports of IP. Imports of IP. That is, this has been telling me when, if you read, I even published newspaper articles on this subjects in 1990s, because those days this IP was totally unknown, limited to few people. So we did a lot of public awareness programs. We started teaching IP, various universities, and your Science Foundation was involved. Actually, we had a committee, 2-3 committees in Science Foundation talking about this IP, and even we were talking about, I think then the chair was Professor Sirimali. We are talking about Bayh-Dole Act type. You know what Bayh-Dole Act? That is the academics inventors, the university, the USA. The academics inventors, they have a law. They can help the academics. The to invent and to commercialize, start business, come back to university if necessary, and help the university. And it has been happening. Sometime I was in Michigan State University. They were talking about a lot of these things. So academic inventions, and then of course they are commercialization by the academic organization. So that is why we are thinking of, I think then minister was, if I recollection is like, I think Professor Tisavitarna, we were actually, if I recollect, I put up a small draft also. I don't know what happened thereafter. Okay. So anyway, IP basically it's a mechanism for the promotion of creativity. So ladies and gentlemen, that is why creativity is essential. As I know, as I understand, the difference between so-called industrial countries and the developing countries for generations like Sri Lanka, the difference is the creation, use, and management of knowledge, or lack of enough creativity, which brings money to the country and knowledge to the people. Okay, so IP helps to protect invention, to protect IP creative efforts in many areas. In that sense, IP is very important, ladies and gentlemen. That is why I cited that Japanese patent heads 1900, what he said, he realized the importance of IP inventions, creativity. Then, of course, you know what happened. And in Sri Lanka, our first patent granted in 1860 under the British Inventors Ordinance Act. We talk about history, then of course, you know, I don't know how many patents we are making today. I can remember about 10 years ago, actually Vietnam, say for example, they started IP system in 1980s. By 2000, they were having about 2,000-3,000 national patents applications annually. Then it rocketed. So, and you know how now China is doing. Now competition between USA and China, who is going to be the leader in patenting. So these are important things. So invention, patenting means invention means create. So this is intellectual property, ladies and gentlemen. That is why always they are talking about intellectual property. And of course, intellectual property is technological information. So patent information is the most important source of technological information. That's the most modern information. Your textbook and other things may not that updated, but if you know the patent information, patent databases, they carry the most modern information on technology. And that intellectual property that comes through intellectual property. Actually, I was telling some people some time ago, start a company in Sri Lanka for technology sharing company like in Singapore, Malaysia for patent information. Now they have companies, they have paid data, the commercialized databases. If you want any research, continue to do any research. If you don't know the existing level of technology, you may repeat in it again. You invent the wheel again. So to avoid that waste of time, money, and everything, you have to do a research and see whether your proposed research proposal, whether it targets a non-existent solution or probable existent solution. If it is not, only you can go. Whether you can at least to reasonably become happy if you do a real patent search on the particular database, available, updated database. So that is very, very important, ladies and gentlemen. Even you buy technology from somebody, you have to check whether this is actually new or not. Whether somebody has taken by mistake, taken a patent for already existing technology. We had that experience actually. So I have no time to explain. In Sri Lanka, we came across that problem once in making the government department things. So these things come in. Then, of course, transfer technology. This part, any country which is not, which doesn't protect intellectual property, no transfer technology occurs. They may bring some old technology, but not latest. You know it, ladies and gentlemen. I don't, because you are in the technology transfer. I'm not really expert, but you are the expert. But my message is IP is crucial even at technology transfer. Okay, you will not transfer your technology to any country, any person who doesn't want to protect your IP rights. And it is R&D based on information, technological information. That number second, technological information. Same thing apply to R&D. That's simple. Otherwise, you are doing research blindly. And investment. Always investors come to a country on the protection of intellectual property. Even you get a patent, ladies and get a patent for an invention, ladies and gentlemen. If you want to start business, you first have to do a patent. Otherwise, you will not spend money. Your partners, even you have a joint venture, say, others, the people who want to fund, they will not fund it because they want to earn money. There's no free lunch. So that is why this investment comes with some price. So there must be some protection, IP protection for your invention. Then catalyst for new technology and business. This is, ladies and gentlemen, very crucial. Your new invention is a catalyst for new technology, new business. And remember, ladies and gentlemen, whatever you do, it must bring business. And it is new technology, bring in business. Then only it becomes real catalyst in commercialization. And remember, and sometime actually, you have to pardon me. I know some people were really not happy with me also, because when we had the program with some professors of universities about 10-15 years ago with the Science Foundation, the commercialization of inventions and building the relationship between a private sector and public sector. So, so actually, we have so many PhD holders spent on the public fund, and how many PhDs are commercialized? That was the question I raised. So may not be that invention is bad, but there's no environment. So we have to think of all these things, ladies and gentlemen. Even the government has to think, policymakers have to think, rather than keeping the people poor and grabbing the power next time. You have to, the policymakers must think that making the people rich so that they are independent physically and mentally. That is the important thing, ladies and gentlemen. And catalysts of new technology. And actually, in the world, there are some inventions, actually, they are not even really PhD holders, so educated people, ladies and gentlemen, right? And they are just some average people. I'll give you one simple example from Sri Lanka, with your permission. There was a gentleman called Mahipala. He invented a machine, very raw machine, to cut the kaju kernel. Because in Sri Lanka, it was a big problem. Traditionally, we all know, we just crush the cashew nut, and even in our villages, we do it and we eat the nut, just it's broken mostly. And it happened even when they do little bit industrially. So what they did was, don't blame me for saying that, we were told that some industries, they introduce some gum and make a broken nut one. Then of course it comes back later on, because some countries, they don't eat like we as in Sri Lanka, junk, right? So this gentleman, he was in Kajugama area. He invented a small raw material machine which cuts the kernel and safely remove the, which cut the nut and very safely remove the kernel. And he approaches, when I was in the IP office, then I directed him to Inventors Commission. We worked there also, a lot of work. Professor Lakshman Jatilika was then the commissioner, and thereafter Dr. Tilakaratna also came. We were working very closely and we helped them a lot. And Professor Lakshman Jatilika, me went all over the country, even in the wartime, to establishing Young Inventors Club. I think still they are running it. So, and this gentleman, the Inventors Commission helped him to patent it. And he started a business. And I came to know over the time that he had earned some money, and he had given employment to about 7 or 9 people. And later on, I was delivering a lecture, Commercialization of Products by SMEs, organized at a seminar organized by Sri Lanka Industry Development Board at Moderator. Then, of course, I mentioned this, ladies and gentlemen. Excuse me for taking time. I'm just giving you some wonderful example. And I mentioned, actually, I don't have many heroes in Sri Lanka, but this is one of my heroes. And I mentioned there is a gentleman like this, and he was originally, with all respect, ladies and gentlemen, is a Winkle Bass, bicycle hadana manuse. And then, of course, with all respect, ladies and gentlemen, and even recently he called me, and then I mentioned about the story. I said he had already given 7 employment. Then he stood up from back and told, sir, Mama, Danata, 70 rasa dila tiyena. You see, one simple man, one simple invention become a catalyst for a man an inventor, and for business. I was told that I don't have much information about that. I was told that he was actually ITI, Inventors Commission, etc. help him, and he was exporting also some machine, if my recollection is correct, to Madagascar, some countries, I don't know, right? So this is just simple example, ladies and gentlemen. Some very minute invention can be, even it may not be very big one, like you have done, and we know our nanotechnology institute, they have done some US patent. And of course, this is very simple. The message I want to share with you is, think of big invention. Of course, high tech is very, very essential. At the same time, there are small things like this. Then, of course, these are the things that we can actually commercialize in Sri Lanka. And of course, sometimes this type of thing we can export to other countries as well. So this is IP that does that job. It becomes IP can create catalysts for new technology and business. Business and industrial strategies. Without business and IP, there is no business and industrial strategy. That is, I would mention about the policy, whether a startup or industrialized or whatever it is. Actually, we did IP and IP audit for a well-known company in Sri Lanka, ladies and gentlemen. The managing director did not know how many trademarks they were having. They were having hundreds, but only using one or two. What's the purpose? So that type of things happen. So you have to be very, you have to have a IP strategy, IP policy in your overall business strategy. Your business plan must comprise IP as an essential component. And commercialization. It is the crucial thing for IP goes to the public through commercialization. We have already mentioned all these things, whether industrial design attracts the consumers, trademarks address the consumers, and new technology addresses the consumers. Without all these things, there is no commercialization. That is why technology, actually, when you talk about intellectual property in Sri Lanka, patenting is not very common subject. Even among the lawyers, it's not that popular because there's no enough patent practice. But mostly trademark practice. Trademark is very active, sometimes copyright. And only few people are involved in patenting. Okay? And I don't know how many people in Sri Lanka we are having with the real expertise with patent drafting. It's another special subject, ladies and gentlemen. You have to be very, very careful. Cover exact your invention, claim your exact invention, and not to cover anything else, not to hide things. If you hide things, that's the danger. So I have a lot of stories to share with you, but I don't want to waste your time for the time being. But it is essential that commercialization and IP is crucial. Not only patent the technology is what you're going to sell. And it is the product you sell and how to sell it. You must know formation of business alliances, formations of business entities, commercialization through the marketing of these things, how you market it, all sort of things. There are things involved. May not be one person can do all these things, but these must be in the strategic plan of your organization. And teaching and education brings patented technology we can use without any purpose. Say your technology, I can use it for teaching purposes, and I can use it for further research, definitely, right? So teaching, when you write a research paper, you write an article that is for the kids for teaching, teachers for teaching, and students to learn. So people don't write books just for nothing, but sometimes we do, because this type of books, when we publish, actually there is no real market. We just cover the cost. It's okay, absolute no problem, right? And of course, IP has consumer protection component. If somebody copies your invented technology and introduce substandard product, IP law comes and protect your invention and prevent that man. If somebody copies your trademark, same thing in the design, industrial design. And in that sense, IP law has the role of protecting consumer interest as well. And of course, state revenue. We are badly lacking now. So how Singapore became rich? They don't have anything except IP. Except IP. Japan, I cited. Even South Korea, all IP, ladies and gentlemen. That is why China has become an economic power through invention, through IP. So if we are to be like this, I don't know, but state revenue, money for the development, not for loans, not for grant. We have been begging, but this has to be, if you want to go out of begging ball, this definitely we have to promote creativity in this country and commercialization, selling the product. Okay, so these are some areas of importance of IP. Next, Trishan. And in the final analysis, IP contribute to the wealth creation and economic growth. It's knowledge, as I mentioned. Creation, use, and management of knowledge make difference between industrialized countries and developing countries for generation, such as the Pearl of Indian Ocean. Okay, so ladies and gentlemen, that's the message, right? So what you are doing is great. You are dreaming for this type of thing. Actually, as the Director General of IP, we were dreaming for this. We are working with universities, those days. So not only universities, actually within our limits. During war, we had only very limited resources, even to recruit staff. So within available resources, we did a lot of work, and this is our dream. So you can actually realize our dream. Okay, so next, Buddha. So it's a subject that says with human creativity. We must learn it and use it. Otherwise, it's a question that we have to pose to ourselves. So thank you very much, ladies and gentlemen. If I said something bad, I beg your pardon and hope it's useful. I'm prepared to answer, clarify if necessary. If you have need any clarification, few minutes, I'm prepared to clarify. Thank you very much for everybody.
Thank you very much. And in your discussion, you said that about the patent information is very important. And at the University of Sri Jawadarpura USD Tech Trans Office, we have both Innovation Q Plus and Derwent Innovation at USD Tech Trans Office, which each one single database will cost about 2 million per year. So any researcher can use these resources. And as the first question, I would like to ask, anyone can ask any question if you have. And first of all, that I would like to ask, as per your experience, what is the main reason for lacking of proper inventions in Sri Lanka? As an example, in USA, there are millions of patents, but in Sri Lanka, there are very few. What is the main reason?
Main thing, I think everything is lack of policy and interest by the policymakers. Because our people have enough intelligence, courage, capacity. You know, when you go to USA, anywhere in any place, you find a Sri Lankan, many Indians, but even one day I was in Monsanto company. I never thought that anybody would be there, but there was a Sri Lankan lady who came and talked to me, Lanka, right? So, and you know, there was a housemaid in Middle East who somehow managed to go to USA with the master and stay there. And I came to know her family, husband and wife, when I was in the George Washington University in 1998. And their son now working as an engineer in NASA. In 1998, he was a kid of 2 years, right? So this is the, ladies and gentlemen, important thing, right? Interest policy that is lacking. And people talk, even I can remember, Mr. Karunarathna was talking very interested. He was very interested in knowledge economy. When he was the Minister of Trade, I was under him. And of course, nothing happened. So we were struggling. Believe me, ladies and gentlemen, when I came to this place from the Attorney General's Department, with all respect to all people, right? I'm telling you that I wanted to have a professional staff to IP office. We had all general clerks running all patents, trademarks, all technical subject, which is highly impracticable. You know it. And then ministry was actually fully supportive. And we went with one Mr. Etiarich, one additional secretary to the Salaries and Card Committee. Then the chairman of the Salaries and Card Committee, first question was, why do you want computers? 1993, this happened, ladies and gentlemen. And this is the policymakers we had. So this is the problem. Whatever we try to do doesn't go to the level. Even once I can remember, we were talking at the budget level in the Treasury. The Treasury Secretary was laughing. He was telling, "Ayo, mona intellectual property." So I didn't know, ladies and gentlemen, cry to or laugh. Whether this is idiocy or something like that, I don't know. So please get the government. I think President was telling this throughout. Get the government to real policy, a strategy to promote creativity and give incentive to creators and patents and try to be a nations of creativity. Otherwise, our people can do it. I have full confidence. I trust you. But the problem is the environment. That's the only reason. If anybody can do it in NASA, Microsoft, why not in Javardhan University, no?
Okay, so thank you. And if anyone have questions, you can unmute and ask. And at the same time, I would like to ask another question. There is a
Trishan, I cannot hear you properly.
There is a registration requirement for copyrights in
no. Like in Sri Lanka, there is no copyright registration system. It's without formality.
Yes, in some countries like US, there are some copyright possibility of registering the copyrights, but in Sri Lanka we don't have. So
sorry.
In Sri Lanka, we don't have a copyright registration system. So what are the measures we can take to protect our...
Actually, not only Sri Lanka, anywhere in the world, under the Berne Convention, registration and any other formality is not required. Okay, even the USA, for member countries of the Berne Convention, the registration in the USA is not necessary. It is mandatory. Recently, US Supreme Court held recently, I think I taught you, right? That for USA citizen is a mandatory. And even recently, few months ago, the Delhi High Court decided that in India, there is a voluntary registration system. For copyright protection, registration is not mandatory. It's a just voluntary system. And of course, it provides some prima facie evidence for proof of ownership. But in Sri Lanka, the law says, once your name appears as the author on the work, then of course, law presumes that you are the author. And consequently, law presumes you are the owner of the rights. So there is no difference.
And sir, what are the documents we need to keep with us to make sure that or prove that that is our original works?
That's the big problem, Buddha, because today you guys write on computers. So when we were in OH, actually our typist type in on the type, and we had copies. So remember always, this has practically risen. So even whatever it is you do on computers, you save each version. I think automatically you can save with the time and date. So I don't know much technology at all, and so you know very well. So save it, save every version until the final version comes out. That is how you have to collect evidence to prove that you are the author.
I would like to ask another question. What is the current status of industrial designs in Sri Lanka? What are the main designs protected in Sri Lanka? Can you give some examples in Sri Lanka?
No, mostly actually, my experience is mostly shoes, shoe designs, like that, very simple things, because you know they change it even sometimes greeting cards, because industrial design can be either 3-dimensional, 3-dimensional, or 2-dimensional, sorry, right? So because it lasts only very short period of time, so my recollection is mostly shoe. In addition, there are many other small things, you know, some pens or various other things also come up. Not many actually. And even recently, one gentleman, while I was delivering a lecture at Karunarathna University, he mentioned about a design of that you have that key tags or something like that, right? So that depends, anything, right? Actually, you are there to do it. Don't think about what others have done. Do it yourself rather than waiting for others and look at what are the areas that be most active, where demand is available. So then, where demand, you have the demand, then introduce design and sell it to the particular industry. Maybe shoes, maybe cloth, t-shirts, anything. I have seen even some of our people are coming with car designs, but it's very difficult because they are very common designs, no? So you have to be very, very careful how to distinguish it from a common design. So don't think about that big designs, but think about the small things like some toothbrush or pen or glasses or something like that, t-shirt or something like that. Okay.
Thank you very much for joining with us today for the webinar on overview of intellectual property. And I'd like to thank all the participants and especially our guest speaker today, Dr. D.M. Karunarathna. So we would like to have another session of in intellectual property. With we are going to have select several topics in future. So thank you all for joining with us. Thank you very much. and have a nice day.
Thank you, Trishan. Thank you.